Hi, today we discuss about timelines in an arbitration process. Arbitration and Conciliation Act under section 29A, as an amended part, now provides for 12 months strict period for completion of an arbitration process. This must be understood that it was never there before, and that's why arbitrations in India generally lingered on for ages. Personally, I have done arbitrations which have 9 years, 10 years also. So that's why it's a great step which has been done by the legislative, and now we have a 12 month period within which it has to be completed. Now, it is important to note that this process, however, has been curtailed to an extent that it does not apply to international commercial arbitrations. Now, what are international commercial arbitrations? I will come to later. But for domestic arbitrations, it is 12 months period, and thereafter, if the parties so agree, they can extend it by mutual consent, only by mutual consent, for another further period of 6 months. So the arbitrators have to endeavor to finish it and complete the entire process within these time frames. There is also, interestingly, some kind of an incentive which has been given to the arbitrators. It provides that if an arbitrator or arbitral tribunal, that's more than one arbitrator, can complete the entire arbitration process within 6 months, there will be some kind of remunerative appraisement of the same. So the arbitrators will have an incentive to complete the process quickly rather than keep it pending. So that is quite the intention of the legislative. Now there is another provision whereas the court, people can approach the court, and then the court can extend the time period. Now earlier it was very clear that if the time period for the arbitration, that is 12 months, not from the date of initiation but from the date of completion of pleadings, that's you give a claim statement and the other party gives the written statement, and is there a rejoinder which is allowed or a counter claim, and all these claims, everything is placed before the arbitrator. From that date, 12 months. And after that, if agreed, 6 months. So after this entire period, either of 12 months or 18 months, if the arbitration process has not been completed, then a party would have to make an application, one of the parties would have to make an application before the court, and it has to be the High Court of that area, and then that court will extend the time period. Now there is an amendment which has made this entire part extremely ambiguous. What has happened is that there's an amendment which has come in, and that says that if you have made an application before the appropriate court, actually it doesn't say appropriate court, before a court, for extension of time, then the arbitration process can continue. It does not need to wait for a decision of the court to extend it. Now imagine what kind of mischief which can be played on this. Supposing let's take an example, 18 months is over. So I will make an application before a court, it says. So I will make an application before a wrong court. I can make an application before a district court. I can make on the wrong High Court. I can just make an application. And that would continue. After, and we keep that application pending, and the arbitration continues, and the arbitration may even end without that application ever being adjudicated upon. Now, I really think the legislative has not really thought about the consequences of what can happen. So the extension application may not be decided, the arbitration can be completed. It can be, while the arbitration process is completed, thereafter we go and that application which I may have filed in a wrong court might get dismissed. Then what happens? Then what happens to the award? Then what happens to the process? I think it's highly ambiguous. And this really needs to be looked into, and the Supreme Court has to decide the contours. under which this can be used, because otherwise there's a lot of mischief which can be played because of this amendment, which is unfortunate. This, I must tell you that this is unfortunate, because this extension of time period also needs to be looked at in two ways. One is that the intention of the legislature was that there should not be additional time given, and only in rare cases for sufficient causes, that is the wordings used, sufficient cause, it should be allowed. So it should be a strict bar. Only in certain cases it should be allowed. Now, 2-3 important issues arise because of that. One is, what happens to cases, supposing they do not complete in 18 months? What happens to those? They have to redo this entire thing before another tribunal. These are, though there are other components in this, that arbitrators' remuneration will be reduced, will be asked to pay back and all that. But in Indian context, these are hardly remedies. Really remedies, no, it's not really a remedy. So one needs to look into the fine print and understand, where does this take us? And to me, this is a dead end. It is just now become like a section 11. You just apply and the courts will give you time for some sufficient reasons, because otherwise what happens to the entire process? One. Second thing is, this does not take it, this entire section 29A and the time periods provided does not take into consideration huge construction contracts and other big arbitrations, where 1.5 years is nothing compared to the voluminous documents where witness action is required, various witnesses, and this time period will require to be given. When in fact, I'll tell you, I applied once for an under section 29A for an extension for 3 years. Other side agreed. The other side said, yes, 3 years, it's minimum 3 years. The judge was like, I have been given 1 year to finish and then you are asking for 3 years extension. Okay, I'll give you maximum 2 years. And I think he gave 20 months, actually he didn't give 2 years also. But that is the kind of thing, because both sides had thousands of pages of documentations to present and then argumentation on that. So these are realities of actual litigation, which I think is lost on section 29A. I need to say that yes, though it is a requirement to have set time limits, but I think that it requires a larger look at the section, the import of it, and categorization of arbitrations, specifically depending upon the amounts which are involved in the various arbitrations. I'm sure small arbitrations which can be concluded within that time frame, it can be, but in many arbitration, this is not possible. So with the hope that this will be looked into, and a lot of ambiguities which have crept into section 29A because of the amendments also perhaps needs to be looked into by the legislature as well as the Supreme Court. So to summarize, please remember that if you want to, you have a time of only 12 months to complete the arbitration. If both parties agree, then you have further 6 months. If not, then you have to make an application before the appropriate court, and I must tell you, the appropriate court is only the High Court, and then after that, the High Court will extend it for a time period. Whether a further extension is allowed, well, there is no prescription against that. So I would presume that you can go on making these applications before the appropriate High Court and continue to get extensions. So the time period can be extended and thereafter you can continue the arbitration. But as I said, there are issues with regard to extension of time like this. There are issues with regard to how mischief can be played on this. And there is, at this moment, I don't think there is much of a pronouncement by different courts or the Supreme Court to really curtail the effect and what is sufficient cause, give an interpretation of that with regard to extension of time. as of now, it is becoming a very routine and almost like an administrative order which is coming out of different courts and giving extension. So, keeping that in mind, I end this today, and I hope I have raised some queries in your mind and raised questions which I have been there now under 29A. If anybody requires any further clarifications, please mail me, and I hope you like the video. Thank you.